Can a landlord raise your rent in the middle of your lease? You just signed a lease. You locked in your rent. You budgeted around that number. And then out of nowhere, your landlord sends you a notice saying your rent is going up next month. Can they actually do that? Is that even legal? Stick around because the answer might surprise you. Welcome to Know the Law. I'm going to break down exactly what your landlord can and cannot do when it comes to raising your rent mid-lease. By the end of this video, you'll know your rights, what protections the law gives you, and what to watch out for so no one catches you off guard. This is information every renter needs to know. What your lease actually protects you from. Let's start with the most important thing. If you are in a fixed-term lease, that means a lease with a clear start date and end date, your landlord generally cannot raise your rent in the middle of that lease term. That is not just a custom or a courtesy. That is the law in virtually all states. Think of your lease as a contract. Both sides agreed to specific terms. You agreed to pay a set amount. Your landlord agreed to accept that amount for the duration of the lease. Changing the rent midway through would be breaking that agreement. Courts take that seriously. Now here's the one exception you need to know about. Some leases contain what is called a rent adjustment clause. That is just a fancy term for a section buried in your lease that gives the landlord permission to raise rent under specific conditions during the lease period. If your lease has that clause, they may be able to do it. If your lease does not have that clause, they generally cannot. So before you panic, pull out your lease. Read through it carefully. Look for any language about rent changes, adjustments, or increases during the term. If you do not see anything like that, you have a strong argument that any mid-lease increase is not valid. What happens when your lease ends? Once your fixed-term lease expires and you move into what is called a month-to-month arrangement, the rules change. Your landlord has more flexibility to raise rent, but they still cannot just do it overnight. There are notice requirements they have to follow. Under most state laws, landlords are required to give you written notice before a rent increase takes effect. Generally, in most states, that minimum notice period is at least 720 hours before the new rent kicks in. Some states have different rules based on how often you pay rent. For example, under some state laws, tenants who pay rent weekly may be entitled to a shorter but still required notice window of around 240 to 336 hours. The point is, written notice is not optional. It is a legal requirement. And if your landlord skips that step or gives you less than the required amount of notice, that increase may not be enforceable. The Federal Fair Housing Act and discriminatory increases. Here is something a lot of renters do not know. Even if a landlord technically follows all the notice rules, there are still situations where a rent increase is flat out illegal under federal law. The Federal Fair Housing Act prohibits landlords from raising rent as a way to discriminate against tenants based on protected characteristics. That includes race, color, national origin, religion, sex, familial status, and disability. So, if you believe your landlord is targeting you with a rent increase because of who you are, that is not just unfair. That is a federal civil rights violation. If you suspect that is happening to you, document everything. Keep copies of any notices, emails, or communications. And consider reaching out to a local tenant rights organization or filing a complaint with the Department of Housing and Urban Development. You have real legal options. Retaliatory rent increases are illegal everywhere. Now let's talk about one of the most important protections renters have, and one of the most misunderstood. It is illegal in virtually all states for a landlord to raise your rent in retaliation for you exercising your legal rights. What does that mean in plain language? If you complained about a broken heater, reported a health or safety violation, contacted a housing inspector, or joined a tenant union, your landlord cannot respond by hiking your rent. That kind of increase is called a retaliatory rent increase, and it is illegal. Some states go even further with very specific legal protections. Under certain state laws, if your landlord raises your rent within 20 hours of you filing a complaint or exercising your legal rights, the law actually presumes that increase was retaliatory. That is a significant legal shift. It means your landlord would have to prove the increase was not retaliation, rather than you having to prove that it was. That kind of legal presumption can be a powerful tool in your corner. Real-world example. Let me walk you through a scenario so this all clicks. Say you have 6 months left on your lease. Your heat stops working in January. You contact your landlord multiple times and nothing gets fixed. So you file a complaint with your local housing authority. 2 weeks later, you get a letter saying your rent is going up by a significant amount next month. First, that mid-lease increase is almost certainly not valid unless your lease has a specific clause allowing it. Second, even if your lease were ending, the timing of that increase coming right after you filed a complaint raises serious red flags. Under the laws of several states, an increase happening within 43 to 20 hours of a tenant complaint is legally presumed to be retaliatory. Your landlord would need to explain and prove a legitimate reason for that increase. Third, if the increase is tied to who you are rather than market conditions, federal fair housing law may also apply. In a situation like that, you want to document everything, respond to the notice in writing, and contact a local tenant advocacy group or legal aid organization as quickly as possible. Wrapping up, here is what you need to take away from this video. Fixed-term leases protect you from mid-lease rent increases in virtually all states unless your lease specifically allows it. Landlords generally in most states must give you at least 720 hours of written notice before any rent increase. Discriminatory increases violate federal law, and retaliatory increases are illegal everywhere, with some states creating a legal presumption of retaliation based on timing. You have more rights than you might think. The key is knowing them before you need them. If this video helped you, hit the like button and subscribe to know the law so you never get caught off guard again. Drop a comment below and let us know what legal topic you want us to cover next. We will see you in the next one.